Thanks for joining us this morning. My name's Lee Fisher. I'm the Dean here at Cleveland Marshall College of Law at Cleveland State University. And we are very appreciative and excited that you're joining us today. We'll have people streaming in all day at this conference that we call the IP Plus Conference because it's a little bit different than perhaps a traditional IP conference, and that's thanks to the wonderful work, first and foremost, to our IP professor, Christa, who you'll hear from in a minute. This conference wouldn't exist if it were not for her. She's been the impetus behind it, but I think she'd be the first to say that she couldn't do it without our fabulous IP Advisory Council. A number of the members are here today, and whether it's Carl or Ari Sherwin, John Cipolla, so many others have been instrumental in putting this together. And I want to say a special thank you to the sponsors. They have been generous, not just financially, but in terms of advice and networking. Tucker Ellis is here today, so thank you, Tucker Ellis. Rich, thank you at Tiroli Sundheim for the wonderful work you do as a premier firm in this space. To John Cipolla, who will be here later, who is the chair of our IP Advisory Council and a partner at Calfee. Hilco Streambank, and of course, Sportech. Thank you all for being here today. We also have a number of students who help us every year, and I want to single out two in particular. Noah Seabrook, are you here? Where's Noah? Thank you, Noah. Thank you very, very, very much. And Claire, thank you very much for what you do, because you were instrumental in helping put this together as well. This is our 125th year as a law school, one of the oldest law schools in the nation, founded in 1897. But even though we are an iconic law school and a seamless part of the fabric, particularly of this legal community here in Cleveland, one of the largest in the country, I think it's fair to say we do not rest on our laurels. We do what Wayne Gretzky used to do. I'm sure many of you have heard the phrase when Wayne Gretzky was asked what made him a Hall of Fame hockey player. He said, "I just learned how to skate where the puck was going, not where the puck was." And that's very much true of legal education. If you're not skating where the puck is going, you're not doing justice to your students and to legal education. So that's why this conference exists today, because this is about where the law is going, not just where the law is. And there's no area of the law that's changing faster and affecting more people and more businesses, from startups to established companies, than IP, innovation, and technology. So you literally are the Wayne Gretzkys of law, as far as I'm concerned, and I thank you for the work that you do. I see John Cipolla just came in, and John, I want you to know, I already mentioned you before you came in, but I wanted to make sure I got full credit, so I'm saying it again. So with that, I want to introduce to you my favorite IP professor on the planet Earth, Professor Christa.
So thank you, Dean Fisher. And I will add that the one thanks that he didn't mention is to himself. He's also been incredibly important in making sure that we can build an IP program here at Cleveland Marshall by helping to build the network of the IP Council, making sure that we have the support that we need on campus, helping give access to donors, and also making sure that that me and the students have the autonomy to create a unique IP program here at Cleveland Marshall. So thank you to Dean Fisher as well. So today, I'm excited for all of you to join. We have an excellent set of panels. We're going to be talking not only about the finance of intellectual property, we're going to be talking about the law of emerging technology, the law of emerging medical technology. We're going to talk through what people who are leading intellectual property practices, both in-house and at firms, deal with as their most significant problems and how they address those. So I'm excited for all of you to learn from these experts in the field. I'm so thankful for the people that came out today, and also special thanks to Laura Quatella. Our keynote today is going to be Laura Quatella, who is the General Counsel, Senior Vice President of Lenovo. and I'm very excited to hear from her as well. Also, I know that it can be difficult to get substance abuse and ethics credit in an exciting way, but we have Ari, who's going to be presenting a substance abuse and ethics credit program mid-afternoon that's going to involve Olympic athletes, Olympic memorabilia, prizes. It'll be way more exciting than your normal ethics CLE. So before we get to the program, I also wanted to tell you about some of the things that we're doing here at Cleveland Marshall to enhance the IP program for our students. We've recently launched a revamping of our curriculum. We have several new IP classes, including one on innovation policy. We have an IP survey class, in addition to some of the classes that we've had before on intellectual property and patent prosecution and other areas, including trademark and copyright. We also have an IP certificate program, and we're continuing to build the intellectual property student group with several speakers that will be coming, including next month, potentially a Q&A on jobs for students with Tucker Ellis. So thank you again to our sponsors, Tucker Ellis, Tiroli, John Cipolla at Calfee, Hilco, and Sportec. And we will go ahead and get started with our first panel. Our first panel is on the finance of intellectual property, and we have experts from every stage of the life cycle. So would Todd, Jennifer, and Russ please come on up, and we'll get you settled. So thank you to all of our panelists here to discuss the finance of intellectual property and all of the business issues that arise when you're trying to consider intellectual property at every stage of the life cycle. Could each of you guys briefly describe, tell us who you are, what your role is, and a little bit about your background so that we have context for the discussion? We can start with Todd.
Absolutely. Thank you for having me. My name is Todd Federman, and I'm the managing director of Northcoast Ventures. We are a Cleveland-based venture capital and angel group. We've been investing for 15 years. About half of our deals have been right here in Cleveland, the rest in Ohio, surrounding Midwest, and a few on the coast. We've evolved a bit over the years to be more specialized. When we first began, we did everything from business software to medical devices, diagnostics, therapeutics, advanced materials, things that tend to have more of an IP portfolio to them. And I'd say over time, we've gravitated more towards business software. But we get involved at the very early stages when there might be 2 to 5 people involved with a company, a minimum viable product, and very early revenue. So it's a point where we expect a lot of risk, about a 50% failure rate, hopefully a lot of fun and potential at the end of the road.
Hi, I'm Jennifer Boyce. I'm the General Counsel and Chief Compliance Officer at the Riverside Company. Riverside is a middle market private equity firm with about 10 billion assets under management. And most of our fund families invest in more of an established type company. So it's software or other IP that's already there, and we're buying that. I will qualify this by the fact that I'm not an IP lawyer. I work with experts like Russ and Todd, and they help me with that. But I do manage IP across the portfolio as well as for Riverside, the private equity firm itself.
So I'm going to stop there. Jennifer called me an expert. That's good enough for me for today, right? So my name is Russ Genat. I'm a director at Longford Capital. Longford Capital is a litigation funding company. My background is I'm a patent lawyer. I spent 20 years litigating and prosecuting patents throughout the country at a firm called Nixon Peabody. It's a large general practice firm. I've always been in Chicago. While I was at Nixon, I spent some time as the head of the IP litigation IP litigation practice group. So to the extent, and some of you know this, anyone had tried to manage lawyers. That was my job for a while. I think that's a misnomer. Nobody manages lawyers. I joined Longford Capital just about 6 years ago. Again, we're a litigation finance company, and so what we do is we invest in litigations. We pay the attorney's fees and expenses related to a litigation in exchange for receiving a piece of any revenue that's generated from litigation. So we fund 3 general types of cases: commercial litigation cases of all kinds, so fraud, breach of contract, class action. We fund international arbitration cases, and then we fund intellectual property cases, patents, trademarks, copyrights, and trade secrets. So since I'm a patent lawyer, I manage a good portion of all of our patent infringement cases. So the one thing that I think to understand about litigation funding and what we do is the money that we provide to your clients to fund any of the litigations is on what we call a non-recourse basis, right? So it's not a loan. We absorb the risk of any loss in the case. We only get paid back if there's money that's generated from the litigation. So what I say is it's a way for you or your clients to shift the risk of litigation to us. The expense of litigation doesn't hit their balance sheets. What does hit their balance sheet, hopefully, is when the case is successful and proceeds are generated. So,
Thank you.
yep.
So each of you guys work with companies that are at very different stages. We have Todd working with very early stage companies, Jennifer working with mid-stage and maturing companies, and then Russ working with companies once they're typically at the very mature stage, and perhaps towards the end of the patent life cycle. Patents generally last about 20 years, and so they may have different roles at different points in both the patent life cycle and the life cycle of those companies. Can you tell me a little bit about how intellectual property plays a role or how it's used at each of those different life cycles? Todd?
Sure. I'd say it is interesting at the earliest stages and becomes more valuable later for us. It's funny to hear a 20-year cycle because in startup world, 20 years is a millennium. To say there's a dog years is probably an underestimating as well. A lot happens in the first 30, 90 days of a company. When companies fail as startups, they're probably dead within 18 months. So oftentimes with the early capital, we're thinking about how do we increase the likelihood of survival as opposed to the magnitude of success. So we tend to look at the IP of what's going to kill us right away, right, versus what are the longer term things we can do. Now there may be certain aspects of IP to carve out, an application here or there, but it's probably less likely that a startup board would support taking a meaningful amount of the capital at an early stage and investing in developing that IP portfolio. It tends to be less about the invention and more about the execution. That said, some of the businesses at the early stage, like devices and diagnostics and advanced materials, are all about the IP, right? You'd never go through all the time and energy to develop and commercialize something if then anyone else can take it. So I'd say it's very much industry specific and stage specific. And in our software realm, I'd say about half the companies have no patents. There's obviously going to be trademarks and a lot of know-how, perhaps some proprietary data that goes into algorithms and developing things that you want to think about how to protect in a broad set, but probably not through a patent, especially at the early stage.
And you mentioned that they might be more open to things like trademarks or trade secrets versus patents. Why is that? I know many of the folks here are practicing and they might be aware of some of those costs differences, but how, what does the cost of getting a patent look like for somebody at that stage? And then we'll circle back to the earlier question for others. I just want to interject with this.
Yeah, so the trademarks are always just a peace of mind also. I think people feel better. Naming is so interesting at the early stages. I'd say at least a third of the companies change their name within the first year. For different reasons. Some because it was a bad name, some because the company actually pivoted to doing something else and the name which characterized what you used to do isn't applicable anymore. And third, because somebody knocks on your door and tells you you have to change your name. And that happens sometimes too. So I'd say, things like trademarks are very big and important to us. Usually though, when an entrepreneur comes to us and says, I've got something patentable, and you say and also I would dispute that I'm an expert anyway on IP, so I'll put that, but when they even say to us, we ask the common sense questions of what do you do that's distinctive, and help us understand how that is legally available to be patented, right? I mean, what type of claims might you make, and how does that compare to what else is out there being used? And often there's a little bit of crickets in the room, right? Because people know they're doing something novel, but not necessarily patentable. So part of what we try to do is just to make sure they're talking to counsel that really understands IP strategy, because oftentimes the initial counsel that helps a startup company get going may be a generalist in nature, right? And is not going to have that deep insight. And we learn a lot from those conversations as well, just to have the context of what might be possible.
Thanks. So circling back to that earlier question of what is the role of intellectual property and how does it affect the businesses at your stage, Jennifer, how does that affect you?
So we, as I mentioned, we're a middle market private equity firm, but most of our fund families are investing in mature companies. So we are, the IP has already been established. So when we're acquiring companies, we're doing a lot of diligence. So we're looking at some of these startups that, are they kind of doing the same thing? Is there any potential infringement on this IP? I mean, it's pretty, with patents and so forth, you can see if you actually own it, but it's really about the diligence at that stage. And then once we acquire a company, it's more, we're more in defend and protect mode, where, whether, a startup comes or, some other company and we need to protect our IP and defend what we own, and protect it, or if somebody comes after us and says, you guys don't really own this, and we have to defend that suit as well. So that's where we are. We do have some early stage funds that are investing, but they're primary minority owners of the company. So we rely on the majority sponsor who is buying that company to do the diligence. But again, since we're minority owners, if there's something wrong with the IP, then we would end up in trouble as well.
That makes sense. And just to follow up with that, you mentioned that when you're doing that diligence for trying to decide when to purchase a company, you might look into the intellectual property. What are some of the things that you're thinking through? And we can get more into this as we get further along in the conversation, but what are some things that you think through about whether it makes sense to buy a company from the standpoint of the value of their intellectual property, or perhaps the freedom to operate that they have?
I think it's largely industry specific. So some industries obviously are much more intellectual. The intellectual property is much more important to them. So if it looks like something that could be a problem as far as ownership or somebody infringing on it, then we'll think about that. Prior to my life at Riverside, I was a deal lawyer, and so always, again, with the diligence is the most important thing is before you do that, because once you get in, defending it can become a very time-consuming and costly process.
Mm-hmm. That makes sense. Russ, so tell us a little bit about how IP plays a role for you. I mean, it sounds like that's the basis of the business, but
Right.
What are some of the considerations that you have?
Yeah, so when folks come to us, they're definitely much later in the process, right, in developing their intellectual property. Usually what we end up with is a client that they've developed their patent. They have a patent portfolio, right? So they probably have 5, 10, 15, or even more patents. And they say, wow, we spent a lot of money developing this intellectual property. They may not be practicing it, right? Oftentimes people aren't practicing the inventions that they've developed. And they've got patents sitting in a drawer. And they said, well, can we do something with this to help generate some revenue, to monetize that IP? And so they'll come to us and say, hey, will we invest in that and help them try to monetize those patents? And our clients look, they span the gamut of types of clients. I mean, we have, of course, sole inventors, maybe small companies, startups that have spent time developing the intellectual property. Maybe they haven't been able to get a product out on the market, but they want to try to generate some revenue with the great IP they've developed, all the way to Fortune 500 companies that have decided patent lawyers are expensive. We don't want to pay them $8 or $9 million to litigate this. Will someone else help us with that? And that's what we will do. So it's very later in the stage of the development, because they've already got a bunch of patents that have been developed. They'll come to us to try to monetize those. And then another example of folks that we work with are universities, because universities, as I say, they are sort of the life's blood of the development of innovation and technology in the United States. They don't make products, right? But they develop great technology, and so we can help them generate some meaningful revenue out of their patents.
It's curious that you mentioned that universities and those who are maybe not able to derive all the value that they could out of their patent might approach someone for litigation funding. But then earlier, Todd had mentioned that startups often have to pick and choose what they're going to do with their patents and how to execute on that. So why is it that it's mostly those mature companies and universities that are towards that late stage that approach litigation funding? Why don't startups and early stage companies say, look, we can't afford to go sue somebody who's infringing our patent, let's go use litigation funding? Or do you see that?
Yeah, I think that, so from the startup side, and I think, Todd, you mentioned this, it takes a while for them to develop their technology and their products, right? And from the university perspective, and I've talked to a number of university, tech transfer office people, and they say, well, startups are hard because a lot of them fail, right? Most of them fail, right? Quite frankly, right? And so I think that why it takes some time is the startups are going to try to develop their product, and if it doesn't work out for them, they still have spent a lot of time and a lot of effort to develop their intellectual property. So then that's when they will bring it to us and say, well, let's try to generate some revenue on that. But circling back on the university side for just a second, universities, what they really love to do, I mean, their patents come out of their tech transfer office, right? And they call it that because their job is to transfer the technology they developed out into industry. And a great way to do it is through startups. They really like to do that, right? Let's create a new business, create jobs. That's what they really want to do, but it doesn't always happen that way. And so what we're able to do, we've talked to universities, is like, listen, there's another way to transfer that technology, and that's to try to go out and license it to folks that are using your technology that can then put that into products and get it out very quickly. And it allows the university to generate revenue that then immediately goes into, they can use to pay for more research and development and other aspects of to help the university in a much quicker time period, because these startups, if they do become successful, it's often 10 years or more before they can generate meaningful revenue, right? I mean, they may generate some small revenue, but like real meaningful revenue. So
thanks. So one of the things that both Jennifer and Todd mentioned was how the industry affects what you want to do with IP for a particular company. Jennifer, I'll start with you. What is the impact of industry in deciding how you're going to use the intellectual property? Are there certain industries where you're going to adopt a different strategy to intellectual property than others, and how does that typically play out?
Yes, I think it depends on again, from the private equity perspective, the companies that we're investing in, it depends on how IP intensive they are, and whether, if you look at the balance sheet, if most of it is IP, then clearly that's going to be, a bigger part of managing the portfolio and of making sure that we are protecting that. So, obviously, software industries, anything that relies on anything IP intensive. We don't really invest in the old time, industrial companies, but there are, and especially in the earlier stage companies, or not Todd's early stage, but the Riverside earlier stage ones, there are, some that, we need to make sure that we are not just defending it, but also growing the IP. Because in the private equity world, it's a little bit different. We invest in companies and grow them and then sell the company. So we're not in a long hold period. So as I mentioned before, and I don't mean to keep harping on this, but it really is defend and protect, because we're selling these companies to make money for the employees there as well as the private equity firm, typically in a 5-year lifestyle. So if they're a software or otherwise IP intensive company, then we will spend the time to monitor that during the whole period.
That makes sense. And actually that brings up another thought that I had. For many of the folks in the audience here are practitioners, legal practitioners in the intellectual property space. Are there ways that you wish, things that you wish outside counsel would know about how to help you with that process of managing intellectual property for the companies that are in your portfolio?
I think just the, sort of proactive thinking. A lot of litigators, and I'm married to one, so I understand, are more of in the, like, going in for the battle, but sort of the proactive thinking about, this could happen, or, I saw this in a recent case, and let's think about how we manage that down the road is a good thing, would be a good thing to do.
Great, thanks. And Todd, back to that question of industry, how does the industry affect how you approach the intellectual property strategy, and perhaps also how you approach your work with outside counsel, or your company's work with outside counsel?
Sure. Maybe I'll take the second one first. And it's really just trying to simplify what it is we're talking about, meaning what is the problem we're trying to solve. I think sometimes it can be a bigger picture conversation about the technology, the long-term, different approach. At the end of the day, it's what are we trying to accomplish here? And to give you an example, in some cases, we don't have something, we need something, and we just need to identify places we can license something from, right? It's a component into what we do. And there's a lot you don't need there, right? First, you just look for a bunch of things that work in a business decision context, and then come in and see if you can license them or see if there's a complementary way to protect. And I think sometimes we've found that those conversations can get a little more academic or broad, and at that point, the meter's running on fees, but maybe more importantly, the CEO and the founding team just only has so much time and energy. And that's probably not their highest and best purpose, right? We want them developing their technology, making it work, talking to customers, those types of things. As far as the industries where we see most of it, certainly devices would be a big one. And as an example, one of our early companies was Neuros Medical, and the CEO basically licensed the technology directly from UH and Case. It was a neurostimulation device, right? That was the basis. There was no company to fund without that technology. And so, we took a look at it. We realized, okay, they patented something, they own something. Then the bet was, does it work, right? Because it worked on rats, right? But a lot of medical devices and innovations have cured cancer in mice and rats, have solved lots of problems in small animals. So it was a bet, but without solid IP at the beginning, we never could have made an investment, not from our perspective philosophically, but because we know that even if they accomplish something clinically, the next larger funders wouldn't invest. That company's gone on to raise, $75 million. Our $2 million round to beginning is just a drop in the bucket. So we need to be thoughtful about what's going to come next and make sure that the IP pieces are in place so we don't preclude the company from making any progress in a year or two, which there are a lot of good reasons to fail as a company. That's not one of them.
Wow, that's really fascinating that you mentioned the need to sometimes strategically consider, are you going to go acquire IP? Are you going to build your own IP, and how you build that? I imagine that for companies, especially at the early stage, that don't necessarily have that strategy skill set in-house, they're going to need to rely on experts to figure that out. And as you said, they can't have the clock just running 100 hours on an academic issue. So what are some of the other tips that maybe you could provide to folks in the audience about how they can help with that strategy? What are some of the things that lawyers can do to make sure that they're keeping that strategic consideration in mind?
Yeah, I think one of the things is actually just expand the number of people in the conversation. That oftentimes the founder and the CEO is the deficiency of the conversation because they haven't commercialized something like this before. They haven't run a company before. And so they're not necessarily able to articulate and represent the business interests in a way that make the legal conversation meaningful. So oftentimes that's where you find your advisors, right? Find people who've been through something like this before, business people, whether it's successful or unsuccessful, who's developed something, commercialized something, brought it to a point and seen around the corner that you're trying to see around, and have a group conversation and game it out, try to better understand. Because unfortunately, sometimes you get a small group of people, you have a plan, you agree that's the plan, and it's the wrong plan. And so we'd love to see investing more time and energy, and it's part of our model as a group where we have several hundred individual investors in our group, and we know who has certain industry experience, functional experience, and has commercialized things. And over the years, we've learned enough to ask a lot of the right questions. We don't know the answers to those questions because they're in specific vertical areas. So you've just got to bring in that level of insight. And I'd say oftentimes CEOs are a little hesitant to do so because it's their idea. They feel like, oh, if I say this out loud, it's going to be a risk. But We encourage people to talk, let people know ideas are not worth a lot without execution. And oftentimes there are people who will take a real intellectual interest in what you're doing and are willing to spend some time and energy without any compensation to be helpful because they're interested in seeing you as a founder or you as a team be successful.
Thanks. And Jennifer or Russ, do you have anything else to add in about sort of tips for how outside counsel can think more about business strategy when they're executing their work?
I think the specialty area is key. We, within Riverside, we have operating partners who are specialists in certain areas, and they go into companies and help with those areas. And, you know, you can bring in, you know, even unrelated to IP, like an expert in the flavor industry or an expert in some other industry. So developing an expertise, I think, is great because that helps you to just hone in, you know, on that skill, and it's really useful rather than getting into the theoretical, you know, IP issues that, you know, executives honestly don't have a lot of patience for sometimes. They just want to know, like, how, you know, what do we need to do to get from point A to point B, and don't necessarily care about the law or the history there. So I think having a specialty area is very helpful.
So the one thing that I'd add from my perspective, you know, as I said, if somebody comes to us, we're trying to generate money, you know, usually it tries with a licensing campaign, which usually ends up into a lawsuit. And I think that what would be real helpful for counsel as you're working with your clients on in litigation and a funding is to make sure that the client has reasonable expectations. Every inventor I've ever met has lightning in a bottle, right? They've got the best patent ever. Everybody infringes it. It's the most valid patent in the world. I'll tell you this. I've never met a defendant yet that when you sue him says, yeah, we infringe. How much do you want me to pay you? It doesn't work that way, right? So there's going to be a fight, and they're going to challenge the validity of your patent. They're going to challenge, say they don't infringe. They're going to file inter-parties reviews. It's going to happen. But the $100 million judgments, the $200 million judgments are very few and far between, and they don't get paid. The federal circuit's going to overturn them, right? So I have people that come to us a lot and say, this is a $500 million case. You would be a fool not to take it. Okay, I'm probably going to turn it down. You know, so I would say just be reasonable. Make sure your clients are reasonable in what their expectations are from litigation, because, you know, ultimately you want someone to cut you a check, right? I mean, a jury verdict for $250 million is, in my view, worth the paper it's written on. It hasn't turned into a check yet into a bank account, and it's going to get appealed probably twice in reality, right? So that's what I would say is make sure that your claim owners, or we call them claim owners, your clients, you know, understand that, listen, if you were to get 30, 40, $50 million or something, that's a really good amount of money to actually get paid to you in a reasonable amount of time. You know, the patent lawyers in the room, you know, there are some cases where, you know, Apple has paid Burnetics over $500 million. That's over a 10-year litigation. Do you want to wait 10 years to try to get that to happen? So that's what I would say. You know, just make sure that your clients have a very reasonable approach in what they're expecting.
That brings me to another great point. You said outside counsel need to be able to prepare your client for what they might expect. But how do you determine the value of intellectual property at a specific stage? And I'd be curious to start with Russ and kind of go back to say, what are the tools you use and the considerations you have for trying to figure out what is that monetary value of the IP you have?
So, yeah, it's a good question. So we start, right, because we're in litigation, we start with the reasonable royalty analysis, right? So that's what we're entitled under the statute, a minimum of a reasonable royalty for infringing your patent, right? So we spend a lot of time in our due diligence trying to figure out what really is the potential damages in the case, so not the infringing sales, but right, what are the damages when you apply a reasonable royalty to the set products that are sold in the United States. And that usually comes up to a really large number for many cases. It does come up to $300 or $400 million. It could be a huge number. That's not what it's going to settle for, but that's what the damages would be. So when we're valuing a case from a funding perspective, that's what we look at. Right, we're looking at sales in the United States times a reasonable royalty. And we often have damages experts help us in the initial stages. Now, understanding that, as I say, a damages analysis before litigation has begun is kind of like shooting darts with one eye closed, right? So, because you don't know all the information, a lot of it's confidential, but we try to do the best guess that we can. And that reasonable royalty can differ by industry. You're mentioning industries, right? And we understand that. If you've got a patent that covers, in the semiconductor field, right, that might cover the memory design of a chip that's in an iPad, okay, well, what's the reasonable royalty? Well, it might be 2 or 3%, but then you have to apportion that, right? Because they don't get to take 2 or 3% of the value of an iPad of $1,000, that's $1,000. It's what is the value of my invention that's on that memory chip that's a part of one of the integrated circuits that's in the iPad, right? So that may end up with an effective royalty rate of 0.1 or 0.2%. It could be very smaller when you do properly apportion it. Versus is something in the pharmaceutical space, right, where maybe the value of my invention is exactly why you're buying the product, right? So like I developed the drug formulation, and that's why it works, and so that royalty rate could be very, very high because it's why you're buying the product. So the industry can change very much on how we value it. So.
Makes sense. And Jennifer, what about you?
So, we value it at the point of acquisition, and that's done by a team of experts that are not me. But the one thing that I get involved in is sort of the value, the cost benefit of litigation. The founders of the companies that we invest in are very tied, they could have been the inventor of the IP. And so they're very, protective of it. And then the transactors at Riverside who invest in the companies are also very protective of it because they want to make sure that the company grows. So when I come in and if we're getting sued or we want to sue somebody, they're very emotional. They can be very emotional about it because they're mostly business guys, and they're like, there's no way that we're infringing or I'm 100% sure these people are infringing on us. We're going to sue. So I have to get involved and say, well, what's the cost of litigation? Because there may not be, it may not be the right road. You may be wronged, no matter what, or if somebody's suing you and you are completely in the right, we've just got to settle this out because it's not worth the, millions, tens of millions of dollars that this could mean with no, real good result at the end of the day. So I'm more involved in the, is it worth going to litigation and balancing the emotions with that?
0 is usually what we assume it's worth at the beginning, and with hopes that it becomes something more. But for us, that IP is really only worth something if the rest of the experiment proves out that there's an underlying market or an opportunity to commercialize it. So, as you get additional cards down, hey, this may be worth more and more, but oftentimes until a company gets some level of maturity, the asset doesn't have standalone value, meaning you couldn't just auction it. So you can't sell it, it's probably worth 0. And at the early stages, our valuation methodologies are generally super simple as well. We're looking at how big a market opportunity is, how much capital is going to go in, what's a reasonable starting structure. So you could sharpen your pencil and do a massive analysis, and I don't know that it would be any better at the early stage. We just want to understand, is there something there to build on that could be more attractive over time? And even in the therapeutic aspect, which Russ developed, it's for a therapeutic at the beginning, you're going to do a series of clinical trials in a very small setting with a limited number of endpoints for a single indication, usually, right? And the first test is you figure out, does it hurt anybody, right? If it doesn't hurt anybody, you get to do another trial. Then you say, does it actually help anybody, right? And then you get some little indication that it does, and you put a lot more money in, and you get a larger sample size and say, okay, does it actually really help people? And then after all that, you start to test it on other indications which grow the market size, right? So at each point, the IP presumably gets more and more valuable, but until you know if the drug kills people or helps people, and then in how many indications you can use it, it's just really hard to determine what the value is. And that's where I think there's just a lot of smart guessing, and then put the guessing away and focus on building the value of the company.
Thanks. So we've talked at a pretty high level about sort of the generalities of some of these strategic considerations, but I'm wondering, do any of you have a story to tell about how intellectual property has either enhanced or perhaps your strategy undermined some business interest?
So I'll add one, and Todd, your story about the therapeutic, I was thinking about it as you were saying it. So I don't know if any of you guys have all heard of the drug Lyrica that's out there. treats fibromyalgia and lots of other pain management issues. And so this was developed by Northwestern University. So there's a professor, Dr. Silverman from Northwestern, who developed that drug. He was the inventor. And so I've met him and I spoke with him, and he, like a lot of professors, at the time, didn't like patents. Right? Patents are awful. Universities are supposed to develop technologies, publish, and get it out there for everybody to improve upon. Noble cause, right? That's great. He develops a patent. Northwestern works with Pfizer. Then they get the patents and they license them out to Pfizer, who then develops the drug Lyrica. Lyrica has been immensely popular. It's generated billions and billions of dollars, and Northwestern's generated a couple $1 billion off of their own for licensing revenue. So Dr. Silverman will tell the story, like, I didn't like patents until we got this drug out there. And he gives a presentation, and he tells about all the work that he did, and he will pull out a stack of letters, and he puts them on the table, and they're like this. Like, these are letters, and I'm going to start reading them. And they're from people that took the drug Lyrica, and it has improved their life. And there are all these people saying, this is the best thing. Thank you for what you've done. You've changed my life. And he said, that's when it hit me that, had we not gotten the patents to cover that, Pfizer would not have spent all the money that Todd's talking about to develop that drug, to say, okay, does it kill people? No, it doesn't kill people. Does it help people? Well, does it help them a lot, right? And that cost hundreds of millions of dollars, if not $1 billion, to develop this drug. And he said, I realized right there that my approach was wrong. That patents, had we not invested in those patents, Pfizer would not have spent the time, money, and effort to develop that and bring that to market. And I would not have this stack of letters from all these people that have benefited from this. So I thought it was a fascinating story. It goes to show, I think, the value of our patent system and really what it helps to develop technology and lets companies spend the money to do what they do to bring products like that to market that help all of us. So I thought it's just a great story from the university thing, and it goes right into what you're saying, Todd, how much it takes to do that. But the patents protected that and allowed it to happen.
So I'll give a bad story.
Oh, okay. You should have gone first.
Yeah. So one of our funds invested in a company and had very strong patents, and it was for the ergonomical design of a piece of baby equipment. And, completely, defensible, everything great. Some other startup came in and started infringing on those patents and, underselling the product that was pretty expensive for a much lower amount. And the CEO and the deal guys were like, this is outrageous, these guys are infringing, we've got to sue. And so the company counsel didn't want to take the suit. They said, for many reasons, it's just not worth the cost. The firm's counsel didn't want to take the suit, so these guys sort of forum shopped for a law firm. A law firm took it and told them that, and it was a New York law firm, said, hey, we are so confident in this suit that we'll do it on a contingency basis. We'll defend it without charging you anything until you get this huge settlement, and then we'll take our fee. It turns out it went on in litigation for 2 to 3 years. They ended up losing. The law firm then ended up billing us for $10 million that we couldn't pay because there was zero win on that's $0. And unfortunately we had to write off the company. So again, that to my point is let's just is it really worth suing? You could be very emotional about whether somebody's infringing on your patent, but it literally destroyed the company, the lawsuit.
You said you were going to tell a bad story. I didn't think it'd be that bad. So I'll tell a good story, just to lighten the mood. Yeah. So one of the companies we invested in is called Standard Bariatrics. And just quick primer on this. So they have a tool for bariatric surgeries, which are laparoscopic. So the patient's out, they make a bunch of holes that are airtight, they blow up the stomach cavity. And in this particular case, for a partial, it's basically a reduction of the stomach size, they use staplers. And staple. So 5 to 6 staples. But there are no staplers made for this procedure, the gastrectomy, the partial gastrectomy. They're only gallbladder staplers. So in theory, it should work. But when you blow up the stomach again, you pull everything out, the stomach comes back, it looks like this, right? Even though these physicians are doing it, because it's really hard to do a straight line. And it turns out that a crooked line is bad because depending on where it's crooked, the patient could have GERD, right, and just have terrible side effects for a long period of time. They may have to redo it. So it's a problem. A bariatric surgeon in Cincinnati came up with a really simple device that goes in one of those holes, opens up, clamps the stomach to give a straight line, and then they do the 4 to 6 staples, right? So it makes a lot of sense. They got IP on it, really nice, simple, elegant, and it was a company we invested in, but their plan was to develop their own stapler. So basically a stapler that was this big, basically the world's most sophisticated staple, that with one staple does 180 staples across 3 different lines and just takes care of the whole procedure. And that is about a $2,500 price as opposed to the $100 for the clamp. So that's pretty good. And if you have a certain market size and you're multiplying by 100 versus 2,500, you know which one you prefer. And the nice thing is that for us, the IP of the clamp covered the whole stapler, right? So we kind of went in there knowing, boy, these guys do have something of value. We don't know how valuable because the stapler might not work, it might not get approved, but fortunately it did work, it did get approved, and the company just last month announced an exit. And it was on a good product that had recently been developed, let's call it a very low 8-figure run rate, but their valuation was way up there because of the vision of what it could be, and you know what this company was buying was the IP. So in that case, kind of hats off to a really nice, elegant, kind of simple strategy, which created a lot of value.
You know, it's fascinating with that example that I think in the med tech space, because it's so difficult and expensive to build those products, it can be a lot harder for somebody to infringe. You know, you could imagine a situation where if you have a simpler patent or something that's less costly to replicate, that you might have more infringers in that, and that might change the story and make it more similar to Jen's, where, you know, maybe if you had a bunch of infringers for that, even though it's this brilliant idea that's really helping people and you have a patent on it, that you might not have the funds to go after infringers. But it seems like in this case, you didn't have infringers that were trying to replicate it either, right?
No, it is a unique dynamic. You're right, because you need all that VC capital to develop this thing, and VCs know what to look for. They're not going to invest in competitors that would clearly be infringing on a patent. And most likely the clinical sites wouldn't sign up to do clinical trials for something that wasn't ultimately going to make it. So I think that really is a valuable competitive barrier, one that we'd like to get more creative and see more opportunities to use in other venues.
Interesting. So it seems like perhaps if your competitors are more sophisticated, you're going to have perhaps more value of having a patent because those competitors are going to respect the patent more than they would in a space where you have a lot of less sophisticated competitors, and it might be more expensive to go after them.
I think that's right. In this case, we were disrupting an industry where there are lots of people with staplers, right? Because staplers are well-off patent surgical staplers. And in that case, there were so many of them that there probably couldn't have been a coordinated response. So a novel strategic situation.
Interesting. So I have one side story that I'll tell on this, also a sort of a negative one. This concept of you know, if you don't think about the value of the case versus what you're going to get, it can be a problem. When I was a litigator at Kirkland & Ellis and then at WilmerHale, and for most of my career I was working with companies, I think I was mentioning to Russ last night, that just had a scorched earth approach. They said, go crush them, spend 10 years doing it, I don't care how much. And so when I got my very first client that I brought into the law firm was not one of those types of clients. It was an individual who had a small company, and his IP was being infringed. And my sort of default strategy was, okay, let's go crush them, right? And then, you know, I start working with a couple of junior associates on it, and then I asked them to go research something, and they have spent 10 hours on it. And I said, oh my gosh, I could have done that in 15 minutes. Why did I have them spend 10 hours? And I said to the partner, can I write it off? They said, no, you cannot write that off. And so then we end up getting about a $400,000 bill for this client. Their insurance caps out around that point. We lose at the early stage, but on grounds where we think, well, we can easily appeal this. This is clearly erroneous. and we say to the client, look, can we go appeal this? This is just plain wrong, plain inconsistent with the law. And they said, no, we can't appeal. We can't afford to appeal this. And so that was a hard lesson for me, and unfortunately for that client as well, that you have to be mindful of the risk that things go wrong, the risk that things cost a lot. And as a lawyer, being able to manage those client expectations of what kind of money they want to put into it, and do they want to go scorched earth? Are they prepared that if you only go halfway, you might not get everything that you wanted? And I think that can affect how the IP strategy works at different stages. If you have a small company, maybe they can't afford to go after people, and they just have to sort of accept that, as Jennifer pointed out, that maybe the right business strategy is to sometimes let an infringer go, which can be a difficult choice. But I suppose as with litigation financing, maybe that can help solve some of those problems.
Yeah, so, Christa, you put your finger on a real issue, which is kind of why we exist, to kind of help, because there is that concept of efficient infringement, right? Which is a company decides, I'm going to infringe on your patent. You got a great technology. We love it. We're going to make those products. Come sue us. It's expensive, right? And most people don't, because it can be very expensive. And we have funded a case with University of California, Santa Barbara on some patents they had on LED technology, and they have said they had a prior case and they didn't have enough money to litigate it, and they couldn't litigate it right because they self-funded it. We've funded another case, and I've been on some panels with their tech transfer officer, and she said the similar thing. She said, well, what's great about with funding is, we provide all that, so we give the clients the ability to properly defend their case or fight their case, right? They've got, we build in budgets for IPRs in the patent case, for appeals, for trials, so the money's there, pre-agreed to what the budget is, and it's fully funded, so it allows these people, clients to bring their case to trial if they need to, and fight the good fight, right? And so we have a number of clients that are very small that couldn't afford, what it costs to defend a patent infringement case, which again could be $8 or $9 million or more. It gives them the access to justice, is kind of how we like to talk about it. Like they have a chance to do something that they couldn't otherwise do and avoid the efficient infringements that are out there. So
I think part of the insight there too is just that you're the objective arbiter of is there value, and to Jennifer's point of somebody having an emotional reaction, they're infringing, let's go get these jerks, right? You're saying, is this going to work? Is this worth my time and energy? That's a valuable perspective.
Todd, it's exactly, because in our process, so what I say is there's at least 3 groups of lawyers that have evaluated a case that we fund, and to say that it's a good case. It's, if you have in-house counsel, the in-house counsel's looked at it. Trial counsel's looked at it because they're willing to take it on our case on a hybrid contingency basis. So they've had to evaluate the case and say that it's strong. We evaluate it in-house. I've spent 20 years litigating patent cases, so I evaluate. I think if this is good. And then we have another stage of due diligence where we send our cases out to our outside counsel to evaluate it. And I tell them, I love this case. You tell me why it's no good. You check it. So if it's a case that we're funding, there's been probably 4 groups of very sophisticated lawyers with expertise in the area evaluate and say, yeah, we think it's good. So it's not a bad case. It's worth the investment.
That's interesting. Have you guys ever run into situations where either the business side or perhaps trial counsel is saying, no, we have to go do this, let's go gung-ho, we're definitely going to win, and you have to make those arguments to them to say, no, we can't do that strategy, that doesn't make business sense? I mean, how have those conversations played out? Do you have any stories around that?
And I think Russ's point is a good one, having several people say this is a good case, because as I mentioned in my bad example, we literally forum shopped for a law firm that would take that. So I think having, if people feel strongly about it, but getting the experts to weigh in, at least a couple, and say, yes, this is a good case, or this is something that you should defend, is important.
And at the end of the day, it's a fight, right?
Yep.
Do you want to get in a fight or not?
It's an expensive fight.
Right.
Yeah.
Expensive and time consuming, and it takes away from running the business, and it's a big decision with several factors involved in making it.
It sounds like folks that are outside counsel need to be mindful that their job is not just to say, how do we win the fight? Their job is to, as you said, be the firm that's going to say, no, we will not take that case if this is if we know that this is going to undermine our business relationship with you, because you're not going to be happy with the business impacts of this case. You're not going to be happy with how much it costs to get what you want.
Right, and somebody's point earlier, it's just, it's not just, a patent infringement suit. I mean, these are people running a business, trying to do other things, and sort of taking the bigger, the holistic approach as to, how is this really going to help this company by doing it overall?
I'll give you one super simple example. Is one of our companies, which was a life science company, got a letter. You never want to get a letter, right? 'Cause nobody sends you anything good in the mail these days. And it said, you shouldn't be using that name. Here's why, you've got X days to stop using that name. In some cases, you'd say, boy, we've got a lot of value on that name. It's customer facing. We put time and energy in this, and we're going to fight this. In this particular case, the company was in clinical trials. No one knew the name, right? We didn't think that they had a great argument necessarily, but it was just imminently easier to say, okay, let's find a new name, right? It just didn't matter. And so everybody around the table, there was no emotion in it. People just said, okay, let's just pick a new name that we know we can own, right? And then there was some time and energy that went into that, and I think avoiding that fight probably saved us some time and certainly some money.
So I'll just add one quick comment on that. What I would suggest, so I value honest feedback from the lawyers that we work with. I think our closest and our best relationships are with the law firms, right? So you all represent different clients, but we're going to probably see a number of cases if it's, from the law firms, right? They're who bring us the matters. And so I get it. Like, my team, we've all litigated cases, and it doesn't always go your way, right? Things go bad. You get a bad Markman ruling, but maybe you get some bad prior art. Stuff comes up. Things happen in litigation, and I get that. But be honest with me. Like, when I want to get an update on the case, don't tell me everything's coming up roses, because it's not, right? Because, there's always something that comes up. Every case has hair on it. But what I really value, be honest, so that we can continue to evaluate that case as things go on. I can report it properly to my investment committee. If we come to a point where it's just, maybe it's time to, cut bait, then let's cut bait, right? And let's decide, I don't want to throw more money after bad if the case is not going our way in one way or another, right? Or maybe we need to settle for less money than we all thought we would get. That's okay, I get it, things happen, but my advice, I think, to all of you is just be honest. If you're working with a funder, be honest with where the case is at, and be honest with your client. Not everybody wins. Some cases win, some cases lose. That's the way it happens, because it's ultimately you got to convince a judge or a jury, and they're just people, right? It's not binary. I wish it was. It'd be easier if it was, but it's not. So just be honest on the status of the case. It's helpful for me, and it helps us build a strong relationship. So.
Thanks. So we've talked a lot about the intellectual property and legal strategy of the companies that you work with, but what are some considerations, legal considerations or intellectual property considerations, that you have to deal with as funders or as part of your own business?
I would hope not many. As a fund, and again, we're a small fund in the Midwest, so we probably have two things going for us. One is we're not necessarily having to play in that larger sandbox where we're going to bump into people in a lot of competitive dynamics. The other is that we have a small fund. We're a relatively small target, right? So we try to cover the basics in our subscription materials, for example. We tell everybody all the reasons why this will certainly be a failure, right? This is going to be terrible. If you read our subscription documents, you would never invest in any fund, right? Because it tells you every single reason that all these companies are going to go broke. And just that simple disclosure, we're hopeful helps to insulate us for future issues. And I'd say one of the things we probably are most concerned about is just running afoul of the SEC, right? So meaning if we are raising a fund, we can't talk about raising a fund in a lot of settings. If a company still has a round open, they should not be doing PR about that round. Just the risk of a general solicitation for us is always significant. And even though we're small and we'd like to think that we're not a great target in that way, boy, would that be tough and expensive and a waste of our time and energy and kind of a stain on the reputation of what you're doing. So we probably go above and beyond in some ways to avoid particular issues where we would have some level of exposure.
So yeah, we definitely have the SEC concern as well. But for every deal that Riverside does, they probably evaluate 100. And there are different fund families who have, they invest in different size companies and different types of companies. So there's a lot of process, procedure, policies. One fund has a playbook. So what we worry about is, employees who are leaving that are maybe going to a different fund or a different firm that's similar, that's sort of taking that. So you can't unlearn what you know, but how, so people are going and doing this and they may not have the actual pages of the playbook, but how do you protect against that sort of IP that really is, how we operate and survive, because it's been developed over 25 years. So that's a tough one. We've had, with employees who have departed, we've had issues where, they are clearly using, what they learned and what is considered Riverside's IP. But do you go out in the market and sue these because you don't want to be the private equity firm that's suing former employees, because then you can't attract new talent. So that's a tricky situation.
No such thing as a non-compete in that space, right?
No such thing as a non-compete, especially in Texas.
So let me address maybe just sort of two issues real quickly on this. The first one, because I'm in a law school, I feel like I need to address a legal issue, which isn't really much of a legal issue anymore. So when people start to talk about litigation funding, it used to come up a lot, the legal principles of champerty, barratry, and maintenance. So I got to say that because we're in law school. I feel like I got to say. So, those are three very medieval concepts that are all about what they call officious intermeddling. So why is this important? Well, in the funding context, people are always afraid of if a funder is taking control of a case, right? So basically, I am now in charge of your case. That's officious intermeddling, right? It's a third party that's taking someone else's case and running it in control. And so if that happens, that would make the funding agreement unenforceable. Actually, in some states, Missouri, there's still a law on the books that makes champerty a crime. It's crazy. Most states have gotten rid of these laws, but Missouri makes it a crime. That is not an issue with the sophisticated litigation funders that know how to do this, because we don't have any ownership of the claim, and we don't run the lawsuit. We have no ability to make decisions in the lawsuit. We don't advise you don't need our permission to do anything. What the funder is getting is actually an equity stake in what we call of proceeds, so of any money that's generated. So first issue, because we're in a law school, I always feel like that's a good thing to sort of talk about and address. It's not an issue because if you structure the funding agreement that we get an interest in the proceeds, we are not controlling the law firm. We're in fact a passive investor, and once we sign the funding agreement, we sit back and we're kind of along for the ride, right? So that's the first issue. The second is the question we get a lot is, if I send you guys stuff because we do a lot of due diligence, is that going to be discoverable? How do we protect that from discovery? We get that question a lot from lawyers because we ask for claim charts, damages analysis, all kinds of stuff. The answer is no. And it is protected by the work product immunity. There is a very large body of case law that has now been developed. For those they're interested, there's the seminal case it's the Miller versus Caterpillar case out of the Northern District of Illinois, which does a great job of analyzing this issue, and it's been followed by pretty much every court that's looked at it. So what's important is that it's protected by work product immunity. So how do you make sure that it's protected? Well, if you work with any reputable funder that knows what they're doing, the very first thing they're going to have you do is execute a non-disclosure agreement, right, an NDA. Not because we want everything to be confidential. It's not why it's there. It's there because that's what the courts have said shows that there's an indication that you wanted to maintain the information confidential. You wanted to show that it was going to have a limited distribution. It's not open for distribution to everybody. And those documents, of course, that are being created that you're sharing with the funder were created in anticipation of litigation. That's why you're doing this, right? So with that NDA in place, that is then evidence for the courts that all that material that's been disclosed to a funder is protected by work product immunity. There are some courts that will extend it to attorney-client privilege under an extension using the common interest doctrine, but that's far and few between. There are some that do it, but most courts will say, well, you have a primary business interest, not a primary legal interest in the case, so it's not really common interest. So what I would tell all of you is that, just if you work with a funder, you make sure you get an NDA in place, and the reason you're doing that is because that will protect it all by work product. And that has been, every once in a while, we'll catch a subpoena with some law firm thinks that they're smart and they want to try to get our documents, and it never goes anywhere. It all, the courts, from the ITC down to district courts all over the country have said, no, it's work product, it's protected. So.
I will add on that how important it is. You know, you say it never happens with you guys because you know what you're doing.
Yeah.
But I have been on cases on the other side where I've been on damages team where we have successfully pursued some and said that that there was not adequate protection there for work product and breached through and gotten claim charts, which was really really helpful. If you're talking claim charts with business people or funders, make sure that there are attorneys involved, make sure that you execute all the agreements, because there are cases where you can break through that. We tried Champerty but didn't win on that one. Yeah. All right, so let's turn it out to the rest of the audience. What are some questions that you have for our panelists? Carl.
I have a question for Jen. As a private equity firm, when you acquire a portfolio company, they have some intellectual property counsel and theoretically intellectual property strategy. Do you guys as a firm get involved in helping them with that strategy, or do you just generally let them do whatever they do?
No, absolutely involved, both at the due diligence phase, where we will hire experts come in to see where they are, and then we have what we put in place before we acquire a company, a 100-day plan. So as part of that plan, it's everything, but some of it could be like, what are we doing with this IP? And do we grow it? Do we give up on it? What it is? So it's absolutely involved in both with the team of experts on the diligence side, and then the first 100 days, and then going forward. Always sort of looking to, again, the private equity, they're not in for long-term ownership, they're in to grow the companies and make companies better, so they're sort of looking at the 5 to 7 year plan as well.
Any other questions? Yeah. Chris?
Yes, Russ. If you don't have control over the litigation, how do you prevent the patent owner from taking something that might be low?
Yeah, that's a great question. So part of it is the due diligence process, right, that we go through. So what part of our due diligence isn't always just looking at the merits of the case, but it's evaluating the claim owner, the client, and making sure that we think that their heads are in the right place, that we can trust them. So that's the first part. So sometimes I've met claim owners that, I think that maybe they're a little unhinged, and I don't think we want to fund their case, right? But so it's really, so it's that piece, right? Making sure we feel that the claim owner is reasonable. The other thing is it's important for us to structure our waterfall, so how money is getting distributed in a way that is beneficial to us, but also allows the client to participate, right? I can't say I need all the money until I get 3 times my invested capital, because the client, it doesn't incent them to take reasonable settlement dollars, right? So we spend a lot of time in just developing what our waterfall structure would look like in a way that ensures that the claim owner or the client is participating at the right levels, so that they can be incented to take reasonable settlement dollars. That I don't want them holding out for, for $100 million settlements. I don't want them to hold out for that. But for small numbers, I will tell you the one thing that in our waterfall structure that you'll find with any funder is that we get first money out until we get paid back our invested capital, right? So if we've invested $3 million, the client, if they don't want to take a $3 or $4 million settlement, they're not going to get anything out of it, right? So because it's all going to pay us back. But then the tweak with that one is to make sure that we don't put too much money in too fast in the case, because if suddenly I'm getting major legal bills and I put a bunch of money in, then the client, they have to take big settlements, right? So it's all in how we structure, how we pay the firms, how we put money out, and then adjusting the waterfall or put it in a way that incents the claim owner to take reasonable settlements. So,
Great question.
Very
Is there
good
another one
question,
over
yeah.
there? Yeah, so what we do is when we fund cases, we will we have the law firm take a hybrid contingency, okay? So
in our typical deal structure, we pay 50% of the attorney's fees, right? In the matter, we pay 100% of all expenses, but the law firm is going to get a contingent stake also, right? So they're going to get a share of proceeds. And then in our waterfalls, generally what happens is we get paid back our invested capital. We get paid back a preferred return of some type, maybe 50, 75% of our invested capital is a preferred return to make sure we have money to pay back our investors, right? I mean, our investors, they want to make money, right? So we got to make sure we get something for them. And then we keep a stake in the outcome. And maybe it's another 10 or 20% contingent share on the last step of the waterfall. The law firm will be sharing in that too, because they're only getting paid part of their fees. So they get paid a contingent share, and then the rest goes to the client. So usually by the time you get to the last step of the waterfall, the client's probably taking, 70%, something like that. That's a really good question. So all of our cases right now, we are funding on the plaintiff side. You can do defense side funding. We have spent a lot of brain power to figure out ways to do that. You've got to have the right case and the right kind of defendant, right? Because the problem on a defense side, usually if you win as a defendant, what do? You walk away. You're like, we're done, right? Thank you, but your patent's invalid or we don't infringe, and we walk away. So there's no money that changes hands. And without any money changing hands, we don't have anything to pay us back, right? So there are ways to do that, but you kind of have to have a claim owner or a client that probably has money that can realize, well, you saved us $15 million by defending ourselves in this patent infringement case, and you come up with some calculation then that they would pay us, but they've saved money and they're willing to pay us, in return. So it can be done. There are very few people doing it. We don't have a case yet. We're looking for the right one, but it's complicated.
I will say on that issue, on the defense side, there are a number of law firms that have unique fee structures that they can put in place for defense, for folks they're defending that they've worked with extensively, to try to find ways that might be something like the equivalent of a contingency fee on the other side. I know Kirkland had a lot of unique structures.
Yeah, defense side funding is the new frontier. It is the way to because I will tell you, we look about this because I will tell you, we fund 4% of the cases we see, right? So 96% of the cases that are presented to us, we're turning down. Well, what does that mean? That means there's 96% of the cases that are better on the defendant side than on the plaintiff side. Well, why don't we get into that business? There's a lot of work there with good cases, so we want to try to figure out how to do that, right?
All right, so we'll cut off questions here so we can set up time for the next panel, but I really appreciate all of you coming and helping out our students and our guests here.
Thank you.
Thank you.